Hello and welcome everybody to today's 2-hour CLE with Dentons. We're pleased to have you. I know that over 500 people have signed up, so we're very excited for today's presentation. We've got a 1-hour CLE about the rise of artificial intelligence and the effect that it will have on employment law issues and on corporate and executive issues, to be followed by a 1-hour presentation on the new tariff rules and the impact under the Trump administration. So let's get started. I'm Louis Pellegrino. I'm at the Dentons Law Firm. I'm the chair of the White Collar and Government Investigations Group there. And before we begin, I'm just going to give you a couple background notes. For the benefit of all participants, the lines have been muted. So if you have any questions during the presentation that you'd like to submit, you can submit them through the question and answer space. And if we can't address your question during today's webinar, we'll follow up after the program. And then relatedly, the webinar is being recorded and it will be circulated to all registrants via email after the event. So if you have follow-up questions at that time, you can please reach out to any of the key contacts for any of the presentations, and we will endeavor to answer your questions once we hear from you after the presentation. And then finally, we can only issue CLE credit for the live broadcast of the webinar. So you have to participate on either a computer or a laptop device. Credit's not available if you join via a mobile device. And then one other important note for those of you who are members of the Bar of New York, New Jersey, Pennsylvania, or Kansas, please listen for the code word that we will give during the presentation. And when you're prompted, you'll need to enter that code word, and that's how you will get CLE credit if you are barred in those states. Okay, so let's begin. Next slide. Okay, I want to introduce our panelists for the top of the hour for the first half of the presentation regarding artificial intelligence, deepfake extortion schemes. As I mentioned, I'm Louis Pellegrino. I'm joined by Anthony Moscato out of our Short Hills office. He is a longtime former prosecutor in the District of New Jersey, where he was the head of the Terrorism and National Security Unit there for many years. And he has some very real-world practical experience on this topic that he's going to bring to bear today. And then we're also joined by Aaron Bass, longtime trial attorney and employment law expert out of our Phoenix and Los Angeles offices. Paul Charlton was supposed to be here as well. So I'm going to do a little bit of double duty, both moderating and a little bit of speaking as well, since he was unable to join us. Okay, next slide. Okay, so here's where we begin when we talk about AI. What are artificial intelligence deepfakes? I think let's start by just viewing this Arnold Schwarzenegger, Julie Garland mashup, which some of you may or may not be familiar with, and then we'll offer some commentary about that. When we play it, we're pulling these YouTube videos live off the internet, so there may be a brief ad or commercial or something before we play it, but let's go ahead and run the clip.
Is there a place you can get to by a boat or a train? Is far, far away? Behind the moon? Beyond the rain? Somewhere over the rainbow, way up high, there's a land that I heard of
Okay.
once in a lullaby. Somewhere over the rainbow, boobies fly, boobs fly over the rainbow.
All right, I think we can go to the next slide since it's cutting out there. So what is the point of that? Well, many of us are familiar with these types of things, these humorous memes. They're both entertaining sometimes or the bane of our existence. Friends and relatives send them around. They're relatively harmless. This one was made several years ago. As I said, it's a mashup of Arnold Schwarzenegger and Judy Garland, relatively harmless. But what we're going to talk about today is the dark side of these AI deep fakes, the ways in which this technology is being used for criminal activity, and how this technology can impact your company, the executives and employees that work for your company, and how it could impact your bottom line. So let's take a look at another example here. This is also an AI mashup of President Obama saying something that he did not actually say because it was a computer-generated fake.
And Tony, if I can just add one thing, the first video that we saw was made approximately 2 years ago by a stand-up comedian in California, whereas the video that we're going to look at now was made approximately 7 years ago by computer scientists at a university. So it goes to show the barriers for entry for generating AI have come so far, where even now unsophisticated individuals can create pretty sophisticated generations using AI.
Okay, well, let's roll this one.
My full-time employees and their ability to survive on $8 an hour in New York City. And foremost in all of our minds has been the loss and the grief felt by the people of Orlando. Most of us don't get our healthcare through the marketplace. We get it through our job or through Medicare or Medicaid. And what you should know is that thanks to the Affordable Care Act, your coverage is better today than it was before. Women can get free checkups, and you can't get charged more just for being a woman. To give his employees come together to pass a common, there's a bill that would boost America's very, very hard times.
Some progress, at least within the small confines of the legal community. I think it's real important.
Here we go. President Barack Obama. When you giving a speech, make sure you use a lot of pauses.
America's businesses have created 14.5 million new jobs over 75 straight months.
We're developing technology. Every technology can be used in some negative way, and so we all should work towards making sure that it's not going to happen. And even one of the interesting directions is that once you know how to create something, you know how to reverse engineer it. And so you can, and so one could create methods for identifying edited videos versus real videos.
Okay, let's go to the next slide. And apologies, I think with the number of people on the system here, the technology is actually running a little bit slow. So, but I think you probably gathered the import of what was happening there, which is that the researchers at the University of Washington had mapped Obama's mannerisms, his manner of speaking, and had taken previous clips to create that deep fake. You saw they spoke there about using a neural, capturing his neural speech and then mapping that onto the image of him. And we're going to talk about that a little bit later in a real life example. Okay, so here are our agenda today. We're going to talk about artificial intelligence. What is it? Just the basics. And how does artificial intelligence impact us in business, in industry, and in the law? These are all areas and topics in which artificial intelligence promises great benefits, but as indicated here, there's also a dark side. So after a brief introduction of AI, we're going to talk about some of the dark side of AI. What are the deep fakes, the fraud, the extortion schemes that modern day criminals and bad actors are using against corporations and individuals today? And then we're going to talk about an actual deep fake scenario that Dentons was involved in. Okay. Next slide. Anthony?
Thank you, Tony. So the first question is, what is artificial intelligence? And I like to go one step beyond that and ask, what is intelligence? What is human intelligence? And human intelligence has several components. One of them is reasoning, the ability to use logic to analyze situations and to develop solutions to problems, uh, using various types of deductive and inductive reasoning, among other things. Next is learning from experience, learning from memory, being able to acquire new information, retain it, memory, and then adapt it and apply it to other situations, much like lawyers do using precedents. Then there's also abstract thinking, comprehension and the application of uh, complex, non-concrete concepts. So that's human learning, several of the components of it. What is artificial intelligence? It's taking all of those things and giving machines the ability to think and act like people. And that includes, as you see, a couple of different types of way that that's done. First is visual perception. That's where machines can use computers, webcams, and other sensors to interpret and understand visual information in the world around those machines. Optical character recognition, OCR, is an example where AI can digest, or machines can digest, a significant amount of text and then provide information concerning the content of the information. License plate readers is another example of visual perception. Next, you have speech recognition, where machines can recognize human speech. They can recognize an individual speaker, such as mine. Siri is an example. And they can also have the ability to convert that speech into text. Siri is just one example, but we'll also talk about chatbots, which are being used in a myriad of different industries, and also voice-controlled devices and smart home devices in your system, in your home system. Language translation, being able to use AI to translate languages. For example, the English language into Spanish is another example of how AI technology is being used. And then next, and the one that we're probably most familiar with, is decision-making, using artificial intelligence to analyze significant amounts of data, in very short amount of time, evaluate options, and select the best course of action to achieve a specific goal to those problems. Examples include autonomous driving, financial trades, where AI is being used to conduct stock transactions, fraud detection, banks with Bank Secrecy Act, and detection of money laundering. And also in e-commerce, when you think about, for example, Amazon or YouTube and the algorithms that somehow mysteriously you're searching one product and all of a sudden it starts to show up in your feed. That's an example of how AI is being used. And just at the bottom, what you see is Harvey. Harvey is an AI platform that is for the legal field. And what I asked Harvey to do was to use artificial intelligence, namely Harvey, to define for us what artificial intelligence is. And you can see its definition there. So we'll go to the next slide. What is generative AI? So this is really what drives the presentation today. And generative AI is using AI, and we'll talk more specifically about certain aspects of it, but using AI to create original text, original images, music, code, and more. And just by way of some examples, and we're going to talk about the dark side of AI and how this is being used, but for example, there are now classical music scores that are entirely written by AI and then being performed by human orchestras. Another example is taking, for example, the music of the Beatles, taking the music of Elvis, inputting it into the system, and then having AI create new songs in the style of and in the voice of Elvis and the Beatles. So it's pretty amazing about how far we've come in a short amount of time as it relates to generative AI. So let's go to the next slide and talk about some of the key components of AI. First is obviously data. It's the foundation of AI. It requires the system to ingest large volumes of data that can include text messages or text, images, audio, video, and other types of information. Next are algorithms, which are just rules or instructions that guide AI. Think of it as a sequence of steps that, when followed correctly, lead to the desired outcome. An example would be, a non-computer example would be a recipe for baking cookies. That's an example of an algorithm. And then the final one that I'll touch on this slide is machine learning. And machine learning is where artificial intelligence learns from data, it improves its performance without explicit programming. So going back to Arnold Schwarzenegger, think of Skynet. And a component of machine learning is what we call, or what is called, deep learning. And this is where computers, machines can perform tasks like image creation and recognition and speech creation and recognition just by learning simple concepts and then being able to replicate that information. So you saw the example with President Obama of using his image and his voice to create a replica of that, a fake. And that's where the term deep fake comes from. Deep learning combined with fake, hence a deep fake. We'll go to the next slide.
And I can jump in here, Anthony, and talk about some of the ways AI is being used for good. You've touched on some of these examples already, but in all different industries, in all different professions, people are using AI to improve things, make things faster, more efficient. You touched on autonomous vehicles and in the transportation space, using AI to monitor traffic and so forth. In the healthcare industry, people are using, medical professionals are using AI to analyze X-rays, MRIs, and other scans to, again, increase efficiency and improve accuracy on reviewing scans. Banks, you touched on, banks are using AI to analyze data and detect fraud. I think we've all seen on any website we do any sort of online shopping on, or other types of websites where virtual assistants or AI-powered chatbots will come on and pop up where you can chat to get some customer assistance quickly, where they can answer basic questions for you. And then in the legal industry, you touched on Harvey, which we use here, but all sorts of law firms are using AI to conduct document review or speed e-discovery issues. There's also AI that can support on compliance and risk management, which is now an expectation of the U.S. Department of Justice for corporate compliance programs. Just by way of example, another recent use for AI that I came across recently is a pro se litigant used AI to draft a EEOC charge. And frankly, the only way we caught it is we saw, her EEOC charge was drafted much more artfully than most of the other emails we had seen this employee draft. But what the real telltale sign was it had citations to legal authority and statutes that when you went to go find did not exist. But yeah, people are using AI for all sorts of different uses. We can go to the next slide, please.
Great. And here's an example of how AI can be used in the law. Those of you who went to law school will remember the rule against perpetuities, or will at least remember that it exists. Many of us have forgotten what exactly it was. But this is an example where we took AI and had the AI system draft a client alert about the current landscape of the rule against perpetuities. AI tends to be very good at this sort of work with some caveats. As Aaron mentioned, there's the false case law problem. So it's important to recognize that AI is only so good as the background information that it's derived from. And when these AI systems work and they basically spread out and canvas the entire internet, keep in mind that they're capturing things from Reddit and Quora and chat forums and people's web pages. And so the accuracy of the information is never always guaranteed. And I think what we've all found in particular, where there's a high risk of inaccurate information, is dealing with case law and statutes, because the systems are not currently connected to Lexis or Westlaw in the way that they probably will be in the future. And so what the systems tend to do, in fact, is they tend to hallucinate, is the word for it. And what that means is that they tend to spit out answers that you want or wish were the law, but are not in fact the law, and they tend to generate cases that do not exist. That is one of the telltale signs that someone is using AI, in fact, is when you go and check the case sites and look up the cases and find out that that quote is not there. Very often, that's a result of using AI. And increasingly, when you see lawyers who get into trouble for using AI, all the time, it's because they used it to generate case sites and other legal citations. They did not check the work. And in fact, they were citing to authorities that did not exist. Now, here's another way that AI can be misused in the law, as we're sort of moving away from the benefits of AI and talking about the dark side. Let's look at this example here regarding an AI attorney. Next slide, please. Okay, so this individual that you're about to see on the right is a fabrication, not a real person. And you will see a real oral argument in which in which the underlying client generated this guy to serve and act as his lawyer. And let's take a look at how that went down.
May it please the court. I come here today a humble pro se
All right.
before a panel of 5 distinguished justices.
Is this, hold on. Is that counsel for the case?
I generated that.
I'm sorry?
I generated that? That is not a real person.
Okay, so what did you see there? That was a New York court engaged in a Zoom argument in which the client employed an AI or deep fake lawyer that he created and generated. And I guess his truthfulness is to be commended. He admitted to the court that it was a fake person that he had created. But the judge pretty much immediately figured out that something was wrong. And I think one of the clues that judges and other practitioners often recognize right away is that AI tends to use overly solicitous language sometimes. This "I humbly come before the court" and "I beg of thee," and it's pulling all of that from background materials, who knows where exactly. But often it just sounds a little bit off. And I think that's what caught that judge's attention. That's why right away she stopped it and said, wait a minute, who is this person? And of course, the client admits, yes, it's somebody that I generated. So let's take a deeper look now at the AI dark side and how people are using that to impact employees and individuals in the business world. Okay, next slide, please. All right. This is
May it please the court.
Next slide. Okay, as promised, this is the code word artificial for artificial intelligence. If you're licensed in New York, New Jersey, Kansas, or Pennsylvania, please enter this word artificial into the system. Type it into the Q&A section of your screen, and then be sure to hit the send button so that registered. Again, that word is artificial. If you're from those 4 states, you enter that into the Q&A section. That's how you will get CLE credit. If you're not from those 4 states, you don't have to worry about that. Again, artificial is the CLE code word. Next slide, please. Okay, Anthony.
Thank you. So now let's move to the dark side of AI. And we'll start with defining a deep fake. And we've already talked about its origins. It comes from deep learning and a fake. And what you're looking at here is an opinion from a federal court in Minnesota just recently defining the term deep fake. And actually, this matter concerned a review of a statute where the legislature in that state enacted a law to make it unlawful to disseminate quote unquote deep fakes with the intent to injure a political candidate. Obviously, looking at the legislature trying to prevent the use of deep fakes to influence voters. And you can see how the court defined what a deep fake is, using artificial intelligence, that generative AI, like we talked about, to manipulate digital content. And that would include a person's likeness, a person's voice, and actions. And the other thing that the court talked about was what I call the barrier to entry. And it talked about how this technology from just in the last 15 years has become so advanced where, again, looking back at the video from Obama, it took computer scientists to put that together. Nowadays, you can have a relatively unsophisticated person who has no experience with technology, is not a computer scientist, using the available tools that are available online to create some pretty sophisticated content, pretty sophisticated deep fakes. And the court continues to say that with the use of social media, that these deep fakes now can be disseminated to millions online with just a mere click of a button. So it presents a real problem for, as we'll talk about, where, you know, for companies and for executives as it relates to fraud, as it relates to other illicit and illegal activities. So we'll go to the next slide. And as it relates to that illegal activity, we're going to focus on 3 areas where deep fakes, where AI is being used to perpetrate and commit offenses against companies, to victimize companies, victimize individuals and executives. And we'll provide some examples related to pornography. It always starts with pornography, fraud, and then what we'll specifically focus on sextortion, and that'll lead us into our scenario. So we'll start with pornography, and we'll go to the next slide. You're looking at an article from The Wire from 2018, and what it was focusing on is how individuals in a certain chat room had shared some software, and it allowed them to take certain celebrities, and I'm not gonna name them, but take certain celebrities and using their images, make them into videos of pornography. And the article, you can tell from the headline, but the article says that using machine learning, that they were able, using AI, to swap celebrities' faces onto porn performers. The result? Fake celebrity porn seamless enough to be mistaken for the real thing. You know, that was the conclusion of this author. The author also says that the law really can help you. And again, this was 2018. Obviously, there were anti-defamation laws at the time that were available to these celebrities and others who were victimized by that. But since then, and just a month or so ago, at the federal level, the president signed the Take It Down Act that made it a crime. Some people might refer to it as the revenge porn statute, to make it a crime to publicize non-consensual publications of intimate images, such as digital forgeries. And at this point, as of this month, 45 states have enacted laws that criminalize AI-generated or computer-edited pornography. So since that time, and based on the rise of this technology, legislatures have actually moved to make much of this conduct unlawful, and the federal statute also has a takedown provision in it. So this is the aspect of pornography, and it also includes obviously adult and child pornography. We'll go to the next slide.
Okay. So we started this presentation showing you the clip of Arnold Schwarzenegger and in The Wizard of Oz to highlight sort of the whimsical, sort of goofy side of AI. But now we're going to talk about the really sinister use of this technology. And this is where it really hits home in terms of if you're an executive at a company, a general counsel, or even an employee. These are the real world issues that illustrate exactly how this technology is being used and exactly how dangerous it can be. Let's talk about this first example of this CNN article. Finance worker pays out $25 million after video call with deep fake, quote, chief financial officer. That's a case from last year, from 2024, out of Hong Kong. It's one that's being talked about quite a bit in the cybersecurity community. And what happened in that case, amazingly, is the company is unnamed, by the way. The Hong Kong police did not identify who it was. But this particular company had a situation in which they lost certain employee ID cards, or they were stolen. Those access badges that everybody uses to gain entrance to the building, that type of thing, those were lost. And then they used that technology that was, the bad actors used that technology that was very similar to what we saw in the Obama video. They combined the stolen identity cards with the AI deepfake technology, and they were able to superimpose the faces of those individuals into essentially what was live action animation. And then what they did is they reached out to this finance worker in the Hong Kong company, and they invited that person to what essentially was a Zoom call. When the finance worker joined the Zoom call, what he saw was a group of individuals that he believed he worked with talking to him, including the chief financial officer, when in fact, those were the AI deepfakes that were created from the stolen identification badges. And of course, you can imagine what happened next. The fake AI deepfake chief financial officer instructed this finance worker to transfer over $25 million to a particular account, saying that it was, and it's always the case, time is of the essence. It's a very secret thing. You can't tell anybody. We need the money immediately. The finance worker was actually duped by this conference call. And I understand that the images were sort of grainy, but he still believed it was the actual individuals that he was talking to. And so he did, in fact, transfer that money. And the company was ultimately out $25 million. Now, the Hong Kong police arrested, I think, more than 6 individuals in connection with the scheme. So they ultimately unraveled it. And I don't know whether the money was ever recouped. But what's important here is that just based on that one loss of those identification badges, the bad actors were able to take deep fake, off-the-shelf, essentially technology, combine those photographs of real people that worked in the company, and create a very dangerous deep fake video that duped one of the financial officers in the company and harmed the company to the tune of $25 million. So, Anthony, why don't you tell us about the next one, which is the WPP scheme involving WhatsApp?
Fortunately for WPP, which is one of the world's largest marketing companies, they actually caught on and weren't duped. But this is an example of an attempt where threat actors created false images of the CEO, fake video of the CEO and fake voice, set up a Microsoft Teams meeting, and then used these AI-generated recreations of the CEO in an attempt to defraud the company. As I indicated, they were able to figure it out. They had that their spidey senses went off. They realized that something was amiss. As you'll see in the Ferrari case, they asked some questions, and that ultimately led to them figuring out that this was a fraud, and they shut it down. The good thing that the company did after this was they used it as an opportunity to conduct an internal investigation, conduct an after-action review, and then use the lessons from this event to enhance their training, to enhance their controls, to ensure that something like this hopefully doesn't happen again for the company. So it's very similar to what happened to Ferrari. And Tony, I'll turn that one back over to you.
Yeah. Thanks, Anthony. The Ferrari one comes to us from Fortune magazine, and this is a really fascinating situation. As Anthony indicated, a very heads-up individual at Ferrari, quote, hit the brakes on this deepfake CEO and actually figured it out at the last minute. So what happened? This was back in July 2024. Now, the CEO of Ferrari is Benedetto Vigna. And there was an executive at Ferrari who received a bunch of messages purporting to be from Mr. Vigna, from the CEO, and they were sent to him on WhatsApp. And they essentially said things like, hey, there's a big transaction coming up. Our lawyer's going to send you a non-disclosure agreement. Again, the time pressure, you need to review it and sign it and send it back ASAP. Stay informed. Please use your utmost discretion. So that's the information that this Ferrari executive gets. Now, unusually, the Ferrari executive received this WhatsApp message from the CEO, and the avatar, that's the image that's associated with the Ferrari CEO, was different than the normal text message that he sent. So already it was a little bit odd, but the bad actors here tried to address that by having the Ferrari CEO, the alleged Ferrari CEO, say, well, I'm using a different phone because this transaction is very important. We have to keep it hush hush. So, this is going to be my means of communicating with you for this particular deal. So eventually what happens is the executive gets on a call with other individuals and purportedly the CEO. And the CEO is about to ask him to undertake a certain transaction, which obviously would have led to the loss of a lot of money on the part of Ferrari, exactly in the way that the Hong Kong company lost money. But this heads-up executive said, he said, "Sorry, Benedetto, but I need to identify you." And then he said, "What was the name of the book that you recommended to me last week?" And the call was immediately ceased. The bad actors hung up. Incidentally, the book was The Decalogue of Complexity: Acting, Learning, and Adapting in the Incessant Becoming of the World. And the reason I mention that is because it's a very important practice tip, and that is this. We had spoken before about how AI is only as smart as the background information that it can obtain from the internet. This heads-up executive at Ferrari asked a question that only the real CEO could know. The very complex title of that book. He said, "Hey, what's the book that you told me to read?" And AI has no ability to answer a question like that. And the FBI actually recommends that exact system in dealing with large dollar transfers or other sensitive items for corporations. The way you implement it would be to have a simple password, something that everybody at the company might know orally, but is not written down anywhere and is not transmitted electronically. And then, for example, if you implemented this system for large wire transfers, if the individual on the other end said, "Okay, ready to transfer the 20 million, but I'm sorry, I need the confirmation word. What is the confirmation word?" And if they don't say bananas or whatever the word is that your company has selected, then you know that you may be dealing with an AI deepfake. Another way that this individual at Ferrari knew, in fact, was because the deepfake was slightly off. Now, in Italy, of course, there are very strong regional dialects. And what I understand from this case is that the CEO of Ferrari was from southern Italy. And the executive expected him to have a particular dialect. And the AI was close, but it wasn't precise. And he thought that it sounded a little bit off. And that was another red flag that prompted this executive to ask the fake CEO, "What was the name of the book that you recommended to me?" And that's sort of similar to the example we talked about before, where the client created the fake lawyer, and the lawyer was sort of overly solicitous, saying things like, "I humbly come before the court." That type of language often AI often derives that from some background thing that it's reviewing and synthesizing. And so when you see those little clues, it might be an indication that there is some deep fake technology at use. And that's where something like the password or asking a question that only the real person could answer can be vital in sorting through these issues. And that's how this one Ferrari executive made a real heads-up maneuver and actually saved the company millions of dollars. Okay, next slide.
So the next example of the dark side of AI that we're going to talk about is sextortion. And as you'll see, we'll also use this type of activity as the basis for our a scenario that we'll analyze the legal issues on. But let's first define sextortion. This is a form of blackmail where a perpetrator threatens to release sensitive or compromising images or information unless the victim complies with demands, usually a demand for money. It is a criminal act in most jurisdictions. Sextortion has existed before AI. The old school way of engaging in this conduct was a threat actor would engage a victim either online or via text message and develop a relationship with them, gain their trust, and then through that relationship, obtain images and videos of them. And their requests for those images and videos may get more explicit, include promises that they'll, send similar images back. And then once the threat actor had a nude or nearly nude photo or video of the victim, then they could use that to engage in threats and blackmail the victim. In the age of AI, the threat actors no longer need to set up the victim. They can just use AI to create the images, the compromising images or compromising videos. As we saw the examples with former President Obama and Arnold Schwarzenegger, they could create a realistic looking video of the victim in a compromising situation. And then they use those fake videos, those deep fakes, to blackmail the individuals, basically threatening to release them unless money is paid or other demands are met. Yeah, so you'll see sort of one way in our scenario that we'll get to next, one way that these deep fakes are used. But really, all they need is an existing image or an existing photo of you to create some pretty realistic videos. They can also use AI to clone a victim's voice. We saw this example in the other fraud scenarios that Anthony and Tony discussed, where they can make it sound exactly like your voice, saying things that you didn't actually say. And then they use those recordings as leverage for extortion. Let's go to the next slide, please.
Okay, Anthony?
Talk about some more examples. The first one that you're looking at is a PSA from the FBI from back in June of 2023. And it involved threat actors, malicious actors who were, again, engaged in this type of sextortion plots, sextortion schemes. But the key takeaway here is that how are the threat actors getting this information to create these fakes? And what the FBI found and what they cautioned about is most of the threat actors, based on the cases that they were receiving, the information was being generated by victims posting information online. This might be posting videos. It could be on YouTube. It could be on TikTok. It could be on the internet. But specifically, social media accounts such as LinkedIn and dating sites and apps. Those are the main sources of information where the threat actors would go to get this information to then use it against their victims. The other thing, and this is from my experiences, in addition to getting that information to generate the deep fakes, the threat actors also use this publicly available information to learn about where the victim lives, whether the victim is married, what the spouse's name is, going so far as to actually, and dealt with this, a real situation where the threat actors were able to obtain information as to where the victim was employed, who the victim's supervisor was, and the supervisor's email and phone number to then transmit this phony information to them as part of the scheme. So it's, that's the lengths that these threat actors will go to carry out their schemes. You see the next unfortunate situation. This is a recent event where some threat actors generated AI nudes of a teenager, then demanded $3,000 from him, and unfortunately, the teen took his own life as a result of being a victim of this really offensive conduct. So this is, it hits home, and it's ongoing, and it's a constant daily thing that law enforcement is dealing with. And then finally, it's not just limited to the United States. There was a deepfake porn crisis in Korea, where they were basically creating pornography, like we've talked about, of girls and women in Korea and putting it in chat rooms, to the point where hundreds of women were victimized by this. And they went into the chat rooms, and there was literally, like, in some instances, 200,000 individuals who were members of these chat rooms that were sharing these photos, to the point where the South Korean government has taken action. They've increased the penalties and become more aggressive as it relates to the enforcement of these types of these offenses. So we'll go to the next slide, and we'll talk about our scenario.
Okay. So this is a scenario that is based on real world experience that Anthony, Aaron, myself have had in terms of real cases. So here's the scenario we're going to talk about. Senior executive of a large public company, and this individual gets text messages on his company phone. And those messages purport to show video claiming that he was soliciting a minor for illicit purposes. And they purported to show this executive on a webcam talking with an underage individual, discussing meeting up and other criminal subjects. Now, these are deepfakes, just as we've been talking about. The threat actors, the bad actors here, they demand money for this executive. They say, we're going to release this video to your spouse and to your company. And if you don't pay me, I'm going to blow you up, blow up your marriage. I'm going to blow up your career. Now, the executive refuses to pay. And the threat actors, in fact, follow through on their threats. And they do transmit this video to the executive's spouse and to the executive's company, to the CEO and to the C-suite. So now everybody knows about it. The senior executive is asserting this video is fake. It's AI generated. He says he's innocent. And the company reacts negatively and chooses to take it at face value in the first instance. So let's look at the next slide. So now, Anthony, why don't you take us through this scenario in terms of how do you handle this scenario and what are the issues that are raised when the individual, the executive, is asserting his innocence and yet the company is seemingly taking this material seriously, as it should be if it were real?
What we'll do is look at it from representing the executive client. And obviously, as you would in any case, you want to do an early assessment of the case, but you also want to take measures to protect your client. So the things that I recommend right away, in fact, there are times when this is done even before the engagement, is making sure that all passwords are changed on all devices, that all passwords are changed on accounts, that there's privacy settings, that those are reviewed and those are enhanced if needed. And also going back to the FBI PSA is to scrub your online presence. And I'll get to engaging forensic experts and the things that they can do, including scrubbing the dark web. But the other thing, again, the scenario is your client is a victim. And what you want to do is ultimately it's going to come to a point potentially where you're going to need to convince law enforcement that that's the case, that your client is in fact not a bad actor, but rather a victim. And to that end, you're going to want to preserve the data, whether that's on a computer, on a phone. A lot of times these threats will come over a phone. So you want to preserve that data, but you also want to, and again, you don't have subpoena power, but what you want to do is get your client's phone records, because a lot of times those I call the toll data, that's the to, the from, the date, the time, etc. That'll give you a good idea as to who your client was and more specifically was not communicating with. The other thing, and again, this is kind of like a helpful tip in talking about avenues of approach for your client, is my experience has been that almost all of the carriers no longer retain the content or the substance of the text messages. So if, for example, a bad actor is texting your client and claims that there are prior communications that occurred months ago, which of course have been fabricated, the law enforcement is not going to be able to issue a subpoena to get that content because those carriers no longer keep the content, meaning the actual text messages themselves, but they will retain the data. So that's something to have a conversation with your client about. You also want to strongly encourage your client to immediately, if not you do it on his behalf or her behalf, immediately file reports with the IC3, that's the FBI's Online Internet Crime Complaint Center, as well as your local police department. The other thing too is having that difficult conversation with your client. It may be that your client was, for example, on a dating site, and again, your client still didn't do anything that was improper or illegal, but that's where the bad actors got that information from. And you want to have that conversation about where the potential sources that the bad actors obtain this information from. And then if the usual circumstance is that that the client has already told the bad actors that he or she wasn't paying, but if you're retained, the question is to pay or not to pay, and there are a lot of considerations, many of which are ethical and beyond the scope, but you want to give really long and hard thought to paying, and the counsel usually is not to pay. And then the other part of this is consulting with a forensic expert. They have the ability and the tools to identify whether the information is a deep fake or not. They'll make a mirror image of the phone or the computer, they'll exfiltrate that data, and then they'll look at the data. And again, you know, the artifacts that they're looking for are going to be systems logs, browser history, the metadata being probably one of the most critical things that they'll look at, and even deleted files. And again, in the situation that I had, the experts were able to go through the contents of this data and were able to tell, based on all the forensic breadcrumbs or lack thereof, is that, you know, the metadata showed that the image that was being sent to the client, his spouse, employer, and others was fabricated, that on his on the device there was no evidence of any prior communications, which was the thing that the bad actors try to represent. So there are things that you'd want to do in terms of bringing in your forensic experts very early on. You also want to maintain custody and control of the device. Again, no deletions of the material. And then you want to start thinking about how you can go on the offensive, especially if the matter is referred to law enforcement. So, you know, the way that my view is, you know, if the client is asserting his innocence, didn't do it, there's really just only two approaches. You either circle the wagons and you leave law enforcement, you leave the prosecution to their proofs, or you go open kimono and you fully cooperate. I would reach out to, you know, again, with the client's approval and consent, reach out to law enforcement, let them know that the client's a victim, that we want to pursue these bad actors, that if we find them, we're going to sue them. If you find them, we want to prosecute them, we'll press charges, we'll testify. I also, again, while our investigation is ongoing, you know, I like to ask law enforcement, like, please don't make any take any type of action to, for example, arrest my client. He's more than willing to come in to meet with you, to speak with you. His phone is being analyzed, and we're going to give you all the results of that analysis, and we'll give you all of the data. So that's how, you know, some of the things that I think about as I'm dealing with the executive client. So I'll turn it back over to you, Tony, to move to the next slide.
Yeah. Next slide, please. Okay. And then what about from the standpoint of the company? If you're on the receiving end of this information, for example, you receive a report or an anonymous email containing these, what in our scenario are deep fake pornography images or evidence, deep fake evidence of criminality. How do you behave? How do you conduct the internal investigation? And then we want to talk about what are the employment law considerations. I mean, first, you're probably going to need to conduct an internal investigation. And I think Anthony touched on this, but the importance of counsel here can't be overstated, because you're going to need counsel to engage forensic firms in order to keep that information attorney-client privileged. And you're also going to want to presumably make both findings and perhaps recommendations for ways that you can implement remedial measures to prevent breaches or other events from happening in the future. And it's important to have counsel advice when you're making those decisions so that you can keep information that should be attorney-client privileged, in fact, privileged. Given the time we have left, I want to turn to Aaron, and Aaron, have you talk about what are some of the employment law considerations in this instance. And if the company were to terminate this individual under the scenario that we've given, does the company face later liability because it turns out they terminated somebody over what were in fact deep fake, false evidence against him?
Yeah, it's a great question. I think we can go to the next slide as well, because, you know, from the company's perspective, oh, sorry, go back one. From the company's perspective, you know, you're faced with this situation of you either have an executive who's engaged in some very wrongful conduct, or he's a victim, he or she is a victim of a crime, and that obviously might change your perspective. From an employment law standpoint, it doesn't necessarily matter if the video turns out to be a fake, unless there are certain provisions in the executive's employment contract, which I'll talk about. But from a strictly common law or statutory perspective, in almost every state, I don't know any state that has an employment law protection for someone who's a victim of a fraud scheme that would stop the company from terminating the employee if it happened to be, you know, a fraudulent or a deep fake. So from that perspective, you're probably clear to proceed with the termination. Even if the executive tried to bring a discrimination or retaliation claim, if you've got a reasonable basis to think that video is real, that you had serious questions about whether they had engaged in that criminal conduct, that's probably enough to defend against a claim, a discrimination or retaliation claim, to give the company a legitimate business reason to proceed with a termination. I think you would, depending on exactly what the sorry, let me rephrase that. Depending on the exact type of conduct that's depicted in the deepfake, you may want to double check applicable state law. If it's not criminal conduct, if it's just, morally offensive, but not necessarily criminal, some states like California and New York will have protections for lawful off-duty conduct. But in most of these extortion schemes, it's unlawful conduct that's depicted in the deepfake. So unlikely that those off-duty conduct laws would even come into play. Like I said, in terms of legal risks, you'll want to carefully review any employment agreement for the executive, particularly the definitions of termination for cause. If cause is narrowly defined and requires that the executive have actually engaged in unlawful conduct to trigger cause, as opposed to just being accused of unlawful conduct, then you'll need to know for sure whether the video is in fact a deepfake to be able to terminate for cause. That doesn't necessarily mean you couldn't fire the executive for a questionably real video. It's just usually whether severance is going to be owed because it's for cause versus without cause. I'll pause on this topic of whether to refer the matter to law enforcement and maybe circle back to you, Tony, on that. But I want to talk a bit about the risks of a defamation claim. In general, if you're dealing with this issue, you're going to want to maintain confidentiality over the issue to the extent possible. When you're conducting an investigation and deciding what to do, keep it within a need-to-know circle. If you keep it within a need-to-know circle, in most states, there'll be a privilege for those communications that would be a defense to a defamation claim if the video turns out to be fake and the executive is fired as a result. So yeah, I think keeping it within a smaller circle. And then of course, setting aside the legal risk, you'll obviously want to consider general fairness, the value that the executive brings to the company. Those considerations may all impact whether you ultimately decide to proceed with the termination, or if you're going to hold on that decision pending whether you're able to prove whether the video is real or not.
Yeah, so it sounds like, sounds like if you make a hasty determination and the person is terminated, generally speaking, you might be okay under the law, but then you're going to have this deleterious effect maybe that you would have in terms of terminating an executive or a person who could be a key individual, the impact on morale and other considerations that I think still would warrant a serious internal investigation to understand what happened. Is that fair to say?
Yeah, absolutely.
Okay, with the 1 minute we have left, let me just refer to law enforcement, and I'll do that by way of closing remarks. Let me just sum up and talk about cybersecurity incidents generally, not just deepfake AIs, but all incidents. I think people here, if you're not familiar with the IC3 system that Anthony mentioned, that's the Internet Crime Reporting System that the FBI runs. You should be familiar with that before an incident happens. And it doesn't hurt to go look at that page. You can put IC3 into Google and look at it. Of course, you wouldn't file a claim now, but you could familiarize yourself with the reporting system. That's the main system for reporting computer crime in the United States. The FBI wants you to report incidents that relating to cybersecurity. Whether you do so is very much an internal corporate decision that I think should be taken with the advice of counsel. But increasingly, insurance companies, law enforcement, and others are requiring you to file such a report. So I think our advice is that you want to think through these cybersecurity incidents before they happen and have a plan. Have a general understanding of whether you think you would report it or not. Have an understanding of what the IC3 reporting system looks like. Know that the FBI may not always respond because they're getting 2,000 IC3 complaints a day now, illustrating just how serious the problem is. And then lastly, in terms of deepfake and AI, watch your online footprint. You saw the example of people losing their badges, their IDs, and how that can be turned into deepfakes. You want to make sure that company content is policed and that systems, internet systems, Instagram, social media, and things are locked down in situations where others might be able to use it adversely against you. So I want to thank you all again for participating. We appreciate the huge turnout for this presentation, and we're going to turn the program over now to Mike Zolance, who's the chair of Denton's U.S. Regulatory Public Policy and Government Affairs practice for the second half of our presentation.
Well, thanks so much, Tony and Anthony and Aaron. That was a great presentation. I'm Mike Zolance. I'm really happy to be with you all today. I'm joined by two of my colleagues, one from north of the U.S. In Toronto, Paul Lalonde, who is the head of the Canadian Regulatory Practice, a great colleague and also an expert in international trade. And another one of my colleagues in Washington, D.C., Leah Kehoe, who is an associate in our trade compliance practice. And we are going to quickly bring you up to date on the universe of tariff issues that have obviously been top of mind for many companies over the last now almost 9 months. Fundamentally, what we're going to try to step through over the next hour is a baseline understanding of the various authorities that are being used by the United States current administration to impose tariffs, how those track with historical uses of tariffs, an update on where we sit on the tariff timeline and things that are likely on the horizon, some of the implications of the new environment, and if we could skip ahead to the next slide 3, an overview of where we are from the standpoint of the impacts of these on importers, on trade relationships, on sort of general compliance issues that come up in the context of these new tariff implementation practices. And then we'll talk a little bit about how other countries have responded to the tariffs, and then some look ahead to the legal challenges that are underway and things we think may happen in the context of the implementation of these tariffs. So let's kick it off over to Leah to talk a little bit about the trade timeline since the start of this year and sort of where we are on that arc as we sit here today.
Thank you so much, Mike. Hi, everyone. So like Mike mentioned, there's been a lot of developments in the past couple months on the tariff and trade front. And so we've outlined a few of them here. We couldn't possibly get everything to fit on this one slide, but we wanted to give you guys some highlights of some of the major moments, kicking off with April 2nd, which was Liberation Day, where basically it was across the board 10% ad valorem baseline tariff, and a bunch of country-specific reciprocal tariffs too, which took effect a few days later on April 9th, where they were supposed to. And then there was a simultaneous 90-day pause for everybody except for China, to basically give negotiation time and opportunity to folks to come together on some agreements to lower rates. Then on May 12th, we had a US and China agreement down to 30%. Shortly after, there was an agreement with the EU, basically kind of delaying the implementation of tariffs there until further agreements could be made to lower rates. On June 16, there was a UK and US agreement. And then on July 12th, all of the threatened tariffs kind of came into effect. EU and Mexico came in at 30%, Brazil was at 50%, and there was a series of others, an additional 21 countries, which all had a minimum of 20% rates imposed. In July, there were a series of agreements that were finalized: Indonesia, Japan, South Korea, Thailand, Cambodia, and the US. The EU. That was pursuant to the earlier delay agreement with the EU in May. Then on August 7th, there was a huge expansion to over 90 countries that took effect. A few of those are listed there. Brazil and India were up at the highest, followed by Switzerland. The The EU and UK agreements were set pursuant to those earlier agreements they made in May and June and July. And then on August 29th, there was a suspension of the de minimis exemption, which basically removed the threshold, and now duties are imposed for goods under that threshold. They were previously exempted from duties and tariffs. And additionally, before we move on to kind of some of the more authorities for all of these actions, we wanted to give a quick overview of some investigations under Section 232 that have been completed under the Trump administration. So far, we've completed steel, aluminum, copper, and a few for autos and auto parts. There's several that are ongoing. Those are listed there, and we'll get into kind of Section 232 as an authority on the next slide, along with the other authorities. We'll move forward.
So when we think about all of these various tariff measures that have been implemented, it's important to understand sort of where they come from. Some of these statutes have been in existence, as you'll see, for quite some time. In some cases, nearly 100 years in the case of Section 338. But what we really are looking at here is the various mechanisms that are available to any U.S. government when they are evaluating whether to impose or implement a tariff. 232, 201, and 301 have all been in existence for quite some time, were used routinely up until the early 90s, when the sort of first general agreements on tariffs and trade, the GATT, was implemented, and then later when the WTO, the World Trade Organization, and the various implementing authorities of the WTO came into place. But even today, and throughout sort of the last 30, 40 years, these various authorities have been used to investigate and then implement tariff rates. The important thing to understand about 232, 201, and 301 is that all of them require an investigation. They require an administrative process, fact gathering, fact finding. They all tend to be product specific, with the exception of 201, which is really more industry focused. But all of these authorities are designed to investigate potential instances of either unfair trade practices by third countries, or in situations in which specific products coming inbound to the United States are causing economic or domestic harm to core industries. So these are not new authorities. They've been used for quite some time, but the one that has been more recently deployed in the tariff context is IEEPA, the International Emergency Economic Powers Act. For those in the trade space, you may be familiar with this statute as being the underpinning for a significant amount of US sanctions actions. So designation of foreign entities, persons, countries, vessels, aircraft, and other types of assets when they are being used in violation of US foreign policy objectives. So the Iran sanctions program, Cuba sanctions program, the Russia sanctions program, all have a significant underpinning in IEEPA. You can impose trade restrictive measures or blocking of assets under IEEPA in situations where the president declares an emergency. This administration elected to use this same authority to impose the reciprocal tariffs that Leah mentioned across the board on a wide variety of trading partners. The emergency varied by geography. In the case of China, Mexico, and Canada, it related to fentanyl. In relation to all of the other countries, other than those three, it was persistent trade deficits. This authority, which was implemented on April 2nd as part of the sort of Liberation Day strategy and has formed the basis for a significant number of these varying tariff levels, it remains subject to legal challenge. And we'll talk about what that challenge looks like as we go through this, but understand that this is, while not a new authority, it's a new use of it. The last one, Section 338, sort of the oldest of the bunch here, is one that has not yet been deployed, but there has been considerable discussion that it may be used in the future. The reason for that is that it similarly, and unlike 232, 201, and 301, does not require an investigation. It just requires a finding on the part of the president, and it allows for the imposition of up to a 50% ad valorem duty in circumstances where a foreign country either imposes an unreasonable burden on U.S. trade, or in circumstances where it discriminates against U.S. goods in the importation context. So this is one to watch, primarily because of its breadth, that in the event that the IEEPA tariffs are invalidated, it may very well come into play as we go forward. So the impact of this timeline in all of these various authorities is obviously a significantly shifting universe of duties, some of which stack on top of one another. So for example, you may have situations where you have an aluminum or steel related product that is coming from a country that already has a reciprocal tariff. In some of those cases, you actually have to stack these numbers on top of one another and can wind up with an even higher effective duty rate. But this entire climate over the last several months has really created a shift and a significant impact in how various trading parties interact with each other. And just to give both a baseline and an update on how this is impacting business, I'm going to turn it over to Paul now to talk about some of the obligations that already exist, but also how the relationships between counterparties are starting to shift in this new environment. Paul?
Thanks, Michael. Great to be here. So I'm going to talk a little bit about the legal impacts, the business impacts of the tariffs on various participants in the international trade supply chain. The new high tariff, complex tariff environment that we're living in is having major impacts on international business, no surprise. But specifically, as importers, to begin there, it's important to keep in mind that importers have the legal liability for duties imposed by a country, just in the US, but everywhere where duties are imposed. They're also importantly, as importers of record, they're legally responsible for the completion of the customs formalities and for the accuracy of customs declarations that are made when goods are imported. And the risks associated with inaccurate, incomplete, incorrect, erroneous declarations in customs documentation rest squarely on the importer of record. So in a high tariff environment, that risk is exponentially higher because it can result in an import that was previously not dutiable because of the changes in tariff classification or origin suddenly becoming dutiable. So the risks associated with that function that importers carry out of clearing the goods through customs and having the legal responsibility for everything associated with that is much higher, much higher. And what we've seen among our clients in Canada, in the US, and around the world is this has all led to an intensely enhanced focus on the trade compliance functions within companies. All of a sudden, very senior executives want to talk to the people who are in charge of clearing goods through customs, who often reside in logistics departments or supply chain departments or procurement departments. And all of a sudden, these functions that were considered clerical or bureaucratic to a certain degree in companies, all of a sudden have an outsized importance. And what a lot of companies have come to realize is that their customs compliance to trade compliance functions aren't quite up to the task of the new risks associated with the high tariff, the complex tariff environment. So you see a lot of companies scrambling to find support from customs brokerages, customs consultants, international trade lawyers, et cetera, and trying to beef up their ability to respond to all the cascading questions that are coming to their customs people. And it's a challenge. There's a limited pool of people with the right expertise. It's not that easy to recruit and train people in this area. And we're seeing a lot of challenges there. So that's a little bit of the flavor of what it's meant for significant importers. If you want to move to the next slide, I'll talk a little bit about exporters. So on the export side, the seller side, implications as well. The exporter is responsible to the exporter's country's export authorities or customs authorities for export reporting. And again, for the formalities that are involved there and for the accuracy of representations, declarations that are made in export documentation. They're also being pressed a lot by buyers for accurate and validated and certified information on tariff classification and the origin of goods. And both of those things can mean the difference between duties and no duties. So those certifications all of a sudden gain much more prominence. The risk associated with giving them, if they're wrong, also escalates. And the pressure to provide these certifications increases in a high duty environment. And I'm going to talk a little bit more about origin determinations and certifications and tariff classification in a minute, but just understand that these may seem like straightforward certifications to make. Where is a product made? That should be pretty straightforward. It's not. Origin determinations are as much art as science and can be very complex depending on the context. And I'll talk a little bit about that in a minute. And then tariff classification is the same. And one complexity to contend with is that the so-called harmonized system of tariff classification is not entirely harmonized. We are harmonized on a global basis virtually entirely to the 6-digit level of the tariff numbers, the HS codes, but not at the 8 and 10-digit levels of the HS code, where there are some country-specific variations. So a US tariff classification at the 10-digit code might work fine for the US, but might not actually be an accurate or correct or complete tariff classification for purposes in other countries, adding to the complexity. If you want to move to the next slide. The role of brokers. So brokers have all of a sudden become incredibly prominent in supply chains from service providers who are very good at providing support for customs formalities and reporting and sort of easing the administrative burdens associated with the customs function. Their role has become a lot more intense in the high tariff environment. Generally, brokers aren't responsible for the declarations they make on behalf of their principals. They're attorneys, agents, representatives. Generally, they're not the ones left holding the bag if something goes wrong and duties are owed. But brokers often drift away from their broker agent function and offer advisory services. And when they're providing professional advice, like a consultant, to their brokerage clients, where does that drift? Where do they stop being an agent and being an active provider of a service, of a professional opinion about things? And their liability can come into play if they get that wrong. On that point, practice note for all of you, or pro tip, be very careful about standard form agreements with brokerages. They're usually based on a brokerage association boilerplate templates, and they have extremely strong limitation of liability clauses. If you are hiring a new brokerage, or if your brokerage agreement is up for review, do take a careful look at it. There is often room for negotiating the more extreme aspects of LOL clauses. And I always encourage my clients to just not take them because, well, that's That's the boilerplate, that's the standard clause, pushback where he can. Next slide. So the high duty environment leads to people trying to find ways to not pay the duties. So duty relief, that is growing business for brokerages, for consultants, for lawyers like us. All of a sudden, programs that are designed to provide relief from duties gain an outsized importance in a high tariff environment. There's a number of different relief programs that exist. In the interest of time, I'm not going to walk through all of them, but I will just put a pin in drawback. It's probably one of the more important ones. Drawback, the principle of drawback is the refund of duties on goods that are imported goods that are subsequently re-exported. So if you are importing materials, packaging, products of various kinds, in order to either after having put them in combination with other goods or not, you're re-exporting them, the duties paid at time of import on those inputs can be eligible for drawback, depending on the nature of the tariff at play. The initial IEEPA tariffs that were imposed by the US were specifically stated to not be subject to drawback, but some of the other tariffs and duties may be. So it's something certainly to explore. If you're getting hit by tariffs, that is a program that is certainly worth kicking the tires on to see whether it fits in your circumstances. There's a number of other things people do to try to avoid or delay tariffs. The use of bonded warehouses has skyrocketed. That's something as well that you should speak to with your advisors to see whether it can provide any form of assistance, at least to defer the tariffs that are imposed upon importation. Next slide. So liability for duties. In a low duty environment, we didn't see a lot of litigation about this, a lot of disputes about this. You know, when the duties on imported goods are 0 or 0 to 3%, it's not often something worth fighting about. But all of a sudden, in a much higher duty environment, disputes about who exactly is responsible for the duties, what exactly are the Incoterms that apply to the supply of a particular product, become hugely important. And a lot of contractual issues arise about how in the contractual instruments duties are, or liability for duties are apportioned or assigned. We've had a lot of questions, of course, about whether duties can be considered a form of force majeure. The bad news on that is that generally not. Standard force majeure clauses don't typically cover duties, but again, you have to look at the specific wording of your particular contract. There's issues where duties are of such significance in the economics of a contract that they lead to termination. And then there's a lot of construction contracts, infrastructure development contracts that are on cost plus bases. What happens to the increased cost that's associated with duties? A lot of disputes arise around that. And then cost escalation clauses that provide for the increase of costs if certain instances arise, and often pursuant to certain formulas. Those have become incredibly important to look at as well in the context of tariffs. So there's all kinds of other issues that arise. What's reasonable care in avoiding tariffs in that kind of context? Where you are passing them along, is there going to be pushback? from people downstream that have to absorb the cost. All of these things are leading to a lot of disputes between the contracting parties. You want to move on to the next slide? So I mentioned this before. Mike, how am I doing on time?
You're great, Paul.
All right, good. So rules of origin, where are the goods made? Should be a pretty straightforward question. I think in a lot of instances it is straightforward. An orange grown on a tree in Florida originates in Florida, clearly. But when you're talking about complex goods, it becomes a much more complex issue. There's a general rule in customs that a good originates where there is substantial transformation of the good, the substantial transformation rule. That's the general customs approach that applies generally to the determination of where a good originates for the purposes of customs declarations. But it gets very tricky if you're talking about a country from a country with which the importing country has a free trade agreement. And then the issue under that scenario is, what does the specific rule of origin, the product specific rule of origin in the free trade agreement say about how you determine the origin of goods? And there's a lot of very complicated and technical tariff shift and regional value content rules that require you to look at, in a complex manufacturing good, a detailed analysis of the bill of materials and where all the components themselves originate from, where the labor and other value adds are contributed to the finished product, in order to determine whether you hit a threshold that's sufficient to say, yes, under this trade agreement, you can declare the good as qualifying in a particular country. These determinations often are as much art as science. They can be very difficult in a complex manufactured good, like, for example, an automobile. And there certainly can be lots of disputes about whether you actually meet the threshold or not. And if you get it wrong, again, the implications in a high tariff environment can be very significant and can be retroactive. Because when there is an error detected in a customs declaration, there's an obligation on the importer to correct that error to all the shipments in the last 4 years to which the error applies. So the implications of getting these things wrong can be really devastating. It's also an area where customs authorities in Canada and the US and around the world are increasingly focused on, because all of a sudden it matters a whole lot more than it used to. And there is a potential pot of gold for the auditors, the regulatory authorities, the customs authorities, if they're able to implement verification programs and it results in duties payable. So it's an active area of enforcement priority for customs authorities, and it's certainly something that companies with large international supply chains have to be very focused on and make sure that their customs function is doing properly. Next slide. So that's it for the things that that I wanted to cover. So I'll pass it back on to Leah and Michael, and I'll chime in when we're talking about the response of other countries to US tariffs.
Sounds good. Thank you, Paul. Before we jump back in, as was mentioned at the start of the webinar, we need to take a brief moment to satisfy CLE requirements by delivering the following code word, which is new. So all Kansas, New York, New Jersey, and Pennsylvania attendees must type the word new into the Q&A section of your screen. Please make sure to hit the send button so that it registers. And again, the code word is new. Great.
Okay, so before we talk a little bit about the responses, I think that one, sort of key takeaway from everything that Paul was talking about in the context of shifting obligations or attempts to shift obligations is, one area to be mindful of is new requests from third parties to complete sureties, to complete contractual terms that oblige you to pay for price increases. We're starting to see these more and more frequently now, where a traditional trading relationship, as Paul mentioned, may have been going on for years, but this change in tariff climate is essentially requiring people to think more creatively about ways to deflect or mitigate the costs associated with new tariffs. So just keep in mind that when your supply chain folks are coming to you with new agreements to review, or when you're asked to update or review a new supply agreement or new contractual terms, that you're looking out for things that might create hidden costs that did not exist before. So in this climate, right, it's not just the US who operates in a global trading environment, much as some would hope. Differing countries around the world have responded in different ways. And this sort of reflects a group of three different categories, right? There are those who sort of seek to reach a conclusion, to reach an agreement. There are those where there is an affirmative effort to push back and to challenge the US tariffs. And then there are circumstances where there is a split between sort of the political climate in a country and the economic sort of commercial business universe in that country. So these are just some examples, and we'll step through them of how different countries are responding. We've called these out because they tend to be pretty significant trading partners, but also because from the standpoint of where you may have operations or suppliers, a significant amount of imports do historically come from these geographies. This is not an exhaustive list, but it does kind of cover a good bit of the differences in how countries have approached the response. So notably, even within North America, the response has not been the same. In Mexico, the current government sought to sort of swiftly seek cooperation and some mitigation of the initially very, very high tariff rates related to fentanyl, moving troops to the border, allowing for greater U.S. law enforcement and military cooperation related to cartels and drug trafficking, and also imposing their own reciprocal tariffs on China in sort of a show of solidarity. Because of one of the topics that Paul mentioned, the regional value content requirements that are a big part of the US-Mexico-Canada Free Trade Agreement, there's also a lot of work going on at the business level of evaluating their supply chains, determining whether they meet regional value content requirements, whether they can meet those requirements, assessing whether they may be able to reshore or change their supply chains, even for imports, into Mexico to take greater advantage of the USMCA exclusions. Not to pick on Paul, but the response in Canada was quite the opposite. A very aggressive pushback from the Canadian government, imposition of their own version of reciprocal tariffs. This is evolving over time to a more cooperative effort to bilaterally reduce some of these duties. And in the current climate, there continues to be a lot of discussion around the 5-year review of the USMCA, as we call it here, or the CUSMA, as they call it in Canada, which will occur in 2025, when the three countries that make up the trading bloc can evaluate the effectiveness of that free trade agreement and potentially
2026, Mike.
2026. That's right. We are in 2025. It feels like it's been more than a year. I apologize. The EU, in many respects, is given that it is its own trading bloc, has had fits and starts of trying to negotiate with the United States. There are obviously a lot of sectors that have significant trading relationships with the United States, in particular autos, aircraft, spare parts, and metals. And so that has made negotiation of a single agreement a little bit harder. because major sectors of the European economy are not all located in the same country. So, the pharmaceutical industry, the auto industry, foodstuffs, other types of products, they're not homogenous in terms of where they are produced. And so reaching a final agreement, and indeed then announcing what you thought the agreement was, only to find out that you were wrong, or perhaps the US was wrong, has been a key feature of the EU. They're staying focused on negotiating on key sectors. And indeed, last Friday, a pretty significant breakthrough occurred with the US, where the president issued an executive order that allows the US Trade Representative and the Department of Commerce to create categories of exclusions for any country or trading bloc that has a framework agreement with the US. So that may suggest that some of these existing framework agreements, like Vietnam, like the EU, will have an opportunity for greater exclusions in some of these investigations that Leah highlighted into pharmaceuticals and semiconductors and steel, aluminum, and chips. China is probably the most complex relationship. The negotiations are all very high leverage because they involve a lot of sensitive technologies, rare earth metals, as well as a significant volume of de minimis, or traditionally de minimis, imports. So the way in which the China-US negotiations have gone is, not surprisingly, not exclusive to tariffs. So it's been sectorally focused as well, but it's also involved lifting of certain export control restrictions on the part of the US in order to secure tariff reductions on the inbound side to China, and vice versa. China agreeing to lift certain caps on the export of rare earth metals in exchange for reduced tariffs on inbound goods to the United States. So when you look at that relationship, it is in many respects sui generis amongst trading partners, because the nature of the relationship is so complex, and because it extends to items more than just traditionally manufactured goods. India has demonstrated an assertive refusal to modify its trade posture at all. And indeed, in the face of 50% tariffs ostensibly related to India's continued purchase of Russian petroleum products, the Indian government moved more closely to China, Russia, and even other trading blocs, rather than try to make a solution apparent with the U.S. Notwithstanding that political landscape, the commercial side of the Indian economy continues to try to make inroads with the United States to achieve some sort of relief. So that's a fairly complex one, very similar to Brazil, where there's a significant amount of political opposition to the tariffs and sort of a very public-facing move toward Russia, India, China, even as the commercial side of that equation, both U.S. investors in the Brazilian economy, as well as major Brazilian producers, try to seek relief. And then similarly to the Mexico example in Vietnam, where we saw a very swift effort to negotiate a resolution, a reduction of tariffs, and an effort to try to maintain strong relationships. Although, cautionary note on all of this, it can change. And so it's really important not just to look at this from the standpoint of the sector you are in, or where your suppliers are located, but also how the politics of that market are doing relative to the United States. So we're seeing a lot of clients begin to look at ways to hedge that exposure, become less reliant on a single point of production or a single point of supply, because we candidly expect that this universe is going to continue to change over time. With that, yeah, go ahead, Paul.
Yeah, let me just chime in quickly on Canada in particular, still one of the US's major trading partners. The initial reaction, like you described it, Michael, was the catchphrase up here in Canada was elbows up. which is kind of a Canadian hockey reference about keeping your elbows up in the corner and getting it into the other guy's face. That certainly has changed. We initially imposed countervailing or retaliatory surtaxes on about $60 billion worth of U.S. imports annually. As of September 1, pretty much all of those tariffs have been dismantled, have been removed unilaterally, not in exchange for a particular deal, but just, I guess, as a show of good faith, and also because I think the thinkers in Ottawa at the Department of Finance and elsewhere know very well that tariffs aren't going to help our economy overall. They might make Canadians feel good that their government is looking out for their interests, but they're not actually going to help the GDP numbers. So as of September 1, really, we have tariffs left on just a few items and on steel and aluminum products. So if you're a producer of steel products in the US, you can expect to still continue to face tariffs in Canada. But on other products, generally, they've all disappeared as of September 1. And indeed, on some quirky little products, we've even done the removal of the tariffs retroactive to last March. So it's just a few kind of oddball items. So if you imported vintage automobiles into Canada between March and September, you're going to be entitled to a refund. But I don't expect it's going to have a lot of implications for the clients of our firm or generally. So that's the status quo right now. The first hot intensity of outrage has dissipated, and the focus is much more on trying to find a reasonable modus operandi that's going to work for us, and that's going to be an honorable solution for the U.S. and Canada to move forward. But that's at the Government of Canada, federal government level. We have a very decentralized country in Canada, arguably even more decentralized than in the US. The provinces have a lot to say about this stuff, and there continue to be a lot of provincial measures in place, particularly in government procurement, for example, that are buy Canadian, avoid American, if I can put it that way. Companies in the US looking at opportunities in Canada, you have to step lightly and make sure that you understand the environment you're operating in. And it's really different from province to province. Some provinces have done nothing on this front. Others have imposed very muscular, vigorous, robust measures in this regard, and in fact, terminated contracts and things of that nature with U.S. suppliers. So it's still a bit of a tread lightly environment in Canada, and make sure you understand who you're trying to sell to.
Thanks, Paul. So let's take with the time we have left a little bit of a look ahead. One big area that has come under a lot of discussion is the legal challenges brought to the reciprocal tariffs and the fentanyl tariffs that were imposed under IEEPA. So Leah, if you want to step us through where we are on that case and kind of what's at stake in this particular proceeding.
Absolutely. Yeah, there were developments there as of yesterday, actually. So like Mike mentioned earlier, IEEPA is not a new authority, but its use for tariffs is new. Trump is the first administration to use IEEPA in this way, and that has prompted several legal challenges. One of those we wanted to highlight here is a decision that was handed down August 29th by the Court of Appeals for the Federal Circuit, which held that the trafficking and reciprocal tariffs exceeded authority under IEEPA. And yesterday, the Supreme Court announced that it would hear arguments on that appeal. I think the arguments are set for November, actually. So the case concerns challenges that were brought in the U.S. Court of International Trade, specifically concerning 5 executive orders using IEEPA to impose those trafficking tariffs against Canada, Mexico, China, which Trump had said had not done enough to curb the flow of fentanyl into the U.S., and the reciprocal tariffs, which imposed the minimum 10% ad valorem on all goods. The Federal Circuit held that an agreement upheld the decision of the CIT and held that both categories of tariffs exceeded the authority of IEEPA, specifically given the magnitude of the tariffs, and IEEPA's use for those here were not supported. In the interim, until review is had by the Supreme Court, these tariffs will remain in effect for the time being, but the court basically reasoned that when Congress intends to delegate tariff authority, it's done so explicitly. It's used really specific terms like tariffs, duties, or the structure of the statute is just very clearly concerning tariffs. And to allow IEEPA to support the imposition of these kinds of tariffs of these magnitude would violate the major questions doctrine. Where Congress wants to give the executive branch that kind of authority, the court expects them to do so very explicitly, and the court did not find that explicit delegation here. And so those will be the questions that the Supreme Court will review in November.
So we've gotten a lot of questions generally about what the potential avenues are for this, right? Because there are a lot of ways that the court could view this particular issue. You could consider it as essentially breaking down into, three potential rulings. One, that you could never use IEEPA as a basis for imposing a tariff. The Federal Circuit did not go quite that far, but they did certainly suggest that it would be a very high bar to allow any national emergency to result in an imposition of broad reciprocal tariffs across this wide swatch of other countries. The other option would be to determine that you could impose tariffs under IEEPA, but that you have to have a valid and well-supported reason for doing so, and that the tariff itself would have to be tied to whatever emergency you declared, and that emergency itself would have to be subject to some type of judicial review. And then the third possible outcome is the essential full grant of authority for IEEPA to cover the imposition of a tariff under any declaration of emergency and essentially uphold the tariffs as they stand. So there's a lot of ways to unpack this particular issue, all of which would result in a related question of whether any decision would be prospective or retroactive, and whether the U.S. government would be forced, in the event of losing this case, to repay any of the duties that had been collected under these tariff authorities. So there's a lot to think about with this case. It's going to be, I think, quite meaningful, not just from a trade law perspective, but also from an executive authority perspective. Historically, when courts have reviewed the authority of the president to act under IEEPA, they've given particularly wide deference to the executive branch in declaring a national emergency or a national security emergency. But given the sort of very unusual use of the statute to impose tariffs, I think it's going to be a very meaningful decision, not only for executive power, but also for this statute going forward and how it can be used. So that's but one area to watch as we go forward over the next couple of months. Some other areas to watch that I think are really notable and interesting. One is sort of the expansion and continued use of various trade authorities, which the administration has made clear from the outset is sort of a central underpinning of its economic strategy and its economic plan. So if we can skip ahead to the next slide. From the beginning, and even as the election was unfolding just about a year ago, it was clear that this administration was going to use tariffs as a mechanism for reshaping the U.S. economy, to either force companies to reshore to the United States from a manufacturing perspective, or to try to correct trade imbalances and penalize those countries that had not been as open to U.S. products as we would like. One other big driver of the policy is a very much a distaste for digital services taxation, which is something that Europe and Canada and other markets have explored, which the U.S. has viewed as being particularly damaging to U.S. tech companies as opposed to other industry players. So regardless of where the IEEPA authority question lands, and regardless of whether that authority remains valid, the use of 201, 301, 232 investigations, and potentially even, I guess, reviving 338 as an option are likely to be on the agenda for a couple of reasons. One is it is collecting somewhere between 20 and $30 billion a month for the U.S. economy. And so as a practical matter, when you have that kind of additional revenue rolling in, it's going to be very hard to walk away from that, not just for this administration, but for future administrations. Also, the other authorities that are out there are not new. They may not necessarily be in line with WTO principles. They may not even be consistent with the existing free trade agreements, but nevertheless, they are live and valid authorities that have a pretty well-trod path and an administrative process associated with it. The counterpoint to all of this, of course, is that the economic realities of the tariffs, whether that be inflation or slowdowns in manufacturing or consistently lower job growth numbers, may very well change the way in which these tariffs are implemented. Which brings me to the next point here, which is the increased use of exclusions. Exclusions have always existed under 201, 232, and 301 as a mechanism for companies or sectors or countries to apply for relief from tariffs that might otherwise be imposed. Typically, these have been used in circumstances where the goods at issue are either in exceedingly short supply in the United States or where they are not available in the United States. In other words, there are certain things that you cannot pull out of the ground in America that you can only pull out of the ground in other places. That is foodstuffs, that's rare earth minerals, that's certain formulations of steel and aluminum. There's a range of products that simply are not manufactured in large quantities in the US or not at all. And so traditionally, that has been where exclusions have been used. Under this administration, with the 232 processes and the investigations that have happened, exclusions have been fairly limited. And where they have occurred, they've been done by executive order, which is particularly unusual given the volume of executive orders that have had to been issued in these contexts. On Friday of last week, the president issued an executive order, though, that starts to change the landscape for this, which allows for USTR and Commerce on their own authority and their own initiative to grant exclusions for goods that are either, again, traditionally in short supply or not available in the United States. But those exclusions can only be granted to countries and products from countries that have entered into framework agreements with the United States. So again, the goal here is to encourage, from a policy perspective, other countries to come forward, reach framework agreements with the US, and then be able to negotiate exclusions. The last area to watch as we head toward the end of the year are the deadlines for some of the ongoing 232 investigations. The lumber, wood products, and derivative products 232 and the semiconductor 232 are rumored to be quote unquote complete, but have not yet been announced or issued. Those are the two big ones in terms of areas of emphasis and focus from both a foreign policy as well as an economic impact perspective. So a lot of political pressure, a lot of industry pressure around what the shape of those findings will be. But it is, again, these are some areas to watch as we roll forward. Let's take a pause here and see if there are any questions in the chat before I turn it over to Paul and Leah for any closing remarks or comments on the topics we've discussed today.
Well, I don't see any questions in the Q&A, Michael, but I have one that I hope doesn't ambush you. But you talked about the discretion to grant exclusions that was allowed or granted on Friday of last week, and you talked about the discretion to grant exclusion in the context of a country that has a framework agreement in place. Does that include countries that have existing free trade agreements? Is there clarity around that yet, or is that still ambiguous?
There's not clarity around that point. And it's a really good question because there are a wide range of existing FTAs and agreements that are not the security framework agreements or the framework security agreements, however you classify them, that have been entered into with the UK, EU, and other markets in the last 6 months. That being said, my own view is that exclusions under those processes for Mexico and Canada would be available because there is the reciprocal tariffs, even though some of them have been suspended, related to the fentanyl and trafficking and trade imbalance type findings, right? So in addition to 232 and 301 and everything else that has been going on, that we have sort of, even though perhaps unlawfully or inadvisedly, amended the USMCA by executive action, that I think brings it open. Because if you're going to impose a exclusion to the IEEPA tariffs under under this framework executive order, I think that would be authorized, right? It's interesting, and it sort of relates to that question, Paul, that notwithstanding the fact that we tossed a lot of the USMCA out the window by even taking these actions, we nevertheless remain willing to allow for zero ad valorem duty imports on USMCA compliant goods. Like, in other words, we didn't throw the whole thing out. We just, decided to be a bit selective about it. So I think that the end result of that is that the tariffs that are imposed on non-USMCA compliant goods could be eligible for exclusions because the authority under which they were imposed related to the IEEPA tariffs and not something else. So, all of the agreed suspensions and gentlemen's agreements that have been entered into between the US, Mexico, and Canada bring that fully into the fore. So I would say that yes, right? One could have a exclusion to various to various processes for US, Mexico, Canada relationships. And there we go with 3 minutes to spare. The last question in the chat, which is, what does all this mean for U.S. membership in the WTO and other multilateral organizations? Great question. If I were employed by the Executive Office of the President, I might have a better answer for you. But I will say this. Other nations have already brought WTO challenges to certain of the newly imposed fentanyl and trafficking and trade imbalance tariffs. And so under, given the timeline, at some point, the US will have to appear, participate, or at least be present at the consideration of those challenges. How long that takes to resolve and who is sitting in the White House at the time that the decision is made will, I think, dictate whether we remain engaged in that process and abide by that process. If that decision were to come out tomorrow, which is, of course, unlikely because of the length of time these things take, I would not expect this current administration to embrace it or abide by it. And so therefore, I think it really depends on the political will of whether we are going to continue to participate in these multilateral type trade processes. I will also note, that's back to the earlier point about things that may change. Economic realities are going to continue to drive policy here. And to the extent that, the trade tariff decision-making results in economic pain for the US consumer or economic decline, the reality is that those changes would be made based on economic realities, but could very well be cloaked in a willingness to engage in multilateral dialogue, right? Like how you message around it may change, but the economic realities will be the same.
Let me just chime in on the question of the US and the WTO and what it means. I think if you take the piece by USTR Greer in the New York Times as an accurate expression of the trade posture or trade policy of this administration, which I appreciate can evolve and whatnot. But if it is a real reflection, I think it speaks to a real questioning in the U.S. of the fundamental principles of the WTO, such as most favored nation and national treatment. Those are the two foundational principles of the WTO, and based on that New York Times piece, the appetite to bind itself to those principles in this administration, at least to this reader, seems extremely low.
Well, with all of that, we just wanted to offer our thanks for participating. And I know that Leah has a closing remark to offer, but on behalf of all of us, thanks for participating. And Leah, over to you to carry us home.
Thank you, Mike. Yeah, this is just the formal technical CLE closing. And so thank you everybody for participating. In approximately 30 business days, you'll receive an email with a link to your CLE certificate. Your webinar login details can be used to process these certificates. No additional steps are required. And as a reminder, the code word requirement is only needed if you are seeking credit in Kansas, New York, New Jersey, or Pennsylvania. That's all. Thanks, everybody.